Judgment in the appeal Jones by Caldwell against the First Year Tribunal and Criminal Injuries Compensation Authority.
On the 18th of January 2005, at about 2:20 a.m., a tragic incident occurred on a 6-lane carriageway which links the Dartford Crossing Bridge and Tunnel with the M25 motorway. Mr. Jones was driving a highways agency gritter along the near side carriageway. Slightly ahead of him, in the central lane of the carriageway, was an articulated lorry driven by Mr. Brian Nash. Ahead of him, there was a car which was parked on the hard shoulder of the carriageway. As Mr. Nash's lorry approached, a man called Mr. Hughes ran from near the car into the middle of the central lane, turned towards the lorry, stood in its path, and raised his arms. Mr. Nash braked, but he was unable to avoid hitting the man, who was killed instantly. It seems that Mr. Hughes was determined to kill himself. As a result of the braking, the rear near-side corner of the articulated lorry swerved into the path of the gritter vehicle. There was a collision between the two vehicles, as a result of which the cab of the gritter was destroyed and Mr. Jones was thrown from it onto the roadway. He suffered very severe injuries and now requires full-time care. Mr. Jones applied to the Criminal Injuries Compensation Authority for an award of compensation under the Criminal Injuries Compensation Scheme 2001. His application was rejected on the ground that Mr. Jones was not, as the scheme required, the victim of a crime of violence. Mr. Jones appealed to the First-Tier Tribunal. His case was that when Mr. Hughes ran onto the carriageway, he committed the offence of inflicting grievous bodily harm, contrary to Section 20 of the Offences Against the Person Act 1861. The tribunal dismissed his appeal because it was not satisfied, applying the relevant test, that Mr. Hughes intended to cause harm or was reckless as to whether harm of whatever degree might be caused by his actions. Mr. Jones unsuccessfully sought judicial review of that decision in the upper tribunal, but he succeeded in his appeal to the Court of Appeal. The authority has appealed against that decision to this court. The Supreme Court has decided that it must allow the appeal and restore the decision of the tribunal. It has every sympathy for Mr. Jones and his family, but the fact is that the terms of the scheme do not permit an award of compensation to be made in this case. The leading judgment is given by myself, with whom all the other justices agree. Lord Carnworth's judgment contains observations about procedural aspects of the case. Built into the phrase, a crime of violence, there are two questions which the tribunal must consider. The first is whether, having regard to the facts which have been proved, a criminal offence has been committed at all. That question is for the tribunal, having informed itself as to what the law requires for proof of that offence, to determine as a matter of fact. The second is whether, having regard to the nature of the criminal act, the offence that was committed was a crime of violence. The range of acts that fall within that broad definition may vary quite widely, so the question will have to be determined by looking at the nature of what was done. To wound or inflict any grievous bodily harm on another person unlawfully or recklessly, foreseeing that physical harm to some other person will be the consequence of his act, is a crime in terms of Section 20. So too is the unlawful or reckless application of physical force of any kind to the person, directly or indirectly, so that they suffer injury. The crime that Section 20 defines will always amount to a crime of violence for the purposes of the scheme. The reason why Mr. Jones' appeal to the tribunal failed was that it was not proved that an offence of the kind described by Section 20 had been committed by Mr. Hughes. The tribunal appreciated that the question it had to consider first was whether an offence under Section 20 had been committed. It identified correctly the tests that had to be applied, but it reached the conclusion that Mr. Hughes did not commit that offence. It was not satisfied that the facts of the case demonstrated that Mr. Hughes intended to cause harm or was reckless as to whether harm of whatever degree might be caused by his actions. The question for the Court of Appeal was whether this was an error of law. It held that there was, but it failed to identify a flaw in the reasoning of the tribunal which could be said of that character. He concentrated on the question whether Mr. Hughes' actions amounted in law to a crime of violence. But the tribunal never got to the stage of asking itself that question because of its finding on the facts that a Section 20 offence had not been committed in the first place. The Court of Appeal may have allowed itself to be unduly influenced by its own view that it was highly improbable that anyone who runs into the path of traffic on a busy motorway will not foresee the possibility of an accident and of consequential harm being caused to other road users. The question whether Mr. Hughes did actually foresee this possibility was, however, for the tribunal to answer, not the Court of Appeal. The lesson of this very sad case is that an appeal court should not be too ready to classify issues as issues of law, which are really best left to determination by the specialist tribunal. The court will now adjourn.